Hello friends. Today, we are going to study Article 4 of UCP600 Credits versus Contracts. First let us read the Article 4A paragraph 1. A credit by its nature is a separate transaction from the sale or other contract on which it may be based. Banks are in no way concerned with or bound by such contract, even if any reference whatsoever to it is included in the credit. Consequently, the undertaking of a bank to honor, to negotiate or to fulfill any other obligation under the credit is not subject to claims or defenses by the applicant resulting from its relationships with the issuing bank or the beneficiary. What does it mean? Attention is drawn to sub-article 4a, above, which provides indisputable evidence that sales and other contracts have nothing to do with the credit transaction, which is separate. A contract of sale is a legal contract. It is a contract for the exchange of goods, services, or property that are the subject of exchange from seller, or vendor, to buyer, or purchaser, for an agreed upon value in money, or money equivalent, paid or the promise to pay same. It is a specific type of legal contract. It is true that the letter of credit is based keeping in mind the terms and condition of the contract. However, it is worth noting that LC is an irrevocable undertaking issued by issuing bank. Hence both LC and sale contract are independent to each other. Let's take Article 4A paragraph 2. A beneficiary can in no case avail itself of the contractual relationships existing between banks or between the applicant and the issuing bank. What does it mean? Sub-article 4a also protects the independence of the issuing bank's undertaking further by indicating that such undertaking is not, in any way, affected by the applicant's relationship with either the issuing bank or the beneficiary. Let's read Article 4b. An issuing bank should discourage any attempt by the applicant to include, as an integral part of the credit, copies of the underlying contract, pro-forma invoice, and the like. What does it mean? Sub-article 4b enforces the position that it should be the contents of the documentary credit to which the beneficiary is required to adhere, and that any conditions in the sales or other contract that are pertinent to the actions of the beneficiary must be incorporated into the documentary credit, and must not form part of any integral attachment. This article, especially, provision in sub-article 4b, looks to discourage issuing banks from allowing applicants to attach pro forma invoices or contracts as an integral part of the credit. Behind this change is the lingering question: what is the purpose or aim of attaching a pro forma invoice or contract to a letter of credit? In most cases, it is so that the bank checks the goods description on the pro forma or contract with that which appears on the invoice presented by the beneficiary. But that is not what a credit is saying when it attaches the pro forma or contract as an integral document. The attachment relates to the whole of the document and not just the goods description. What if there are terms in the pro forma or contract that contradict the terms in the credit, or terms in the pro forma or contract that do not appear in the credit? This is the end of the topic. Please like, share, comment. For more videos please subscribe my channel. It's free